on. Thank you. Colleagues, good morning. We see you in our midst. Welcome. Yeah, Asset Dean has joined us this morning. She couldn't make it yesterday, as we said, because of other activities that she had. But luckily, she's here now with us. Why do I have this hissing sound at the end of it? Huh? Sorry?
But I think we'll start at 9:30. They will play some music for us. So they may just be patient for the next 10 minutes.
Yeah. Good. We have good news for you. Very good news. The first good news is that there's a cultural evening this night. For those of you who have watched this dance called merengue, so you better either straighten your shoes, do some stretches, do some push-ups, and get ready. I think for some of you it will be very, very exciting to see some of us on stage doing the merengue dance, right? So I think it will be nice. I've just been informed that for us to prepare for that, we'll have some light music. In 10 minutes we start. We have taken off one of the sessions due to the unavailability of some of the colleagues who are supposed to present online for various reasons. So we will start with the session from 9:30. We'll start with a session that was supposed to start at 10 with Dr. Demand here. It will start at exactly 9:30, so in a few minutes from now. I came across this book just now in the hall. I live in South Africa. We have load shedding. It's a constant thing. So I'm hoping that that when I read this book, I'll be able to advise ESCOM. Right? So I just found the book, that when I advise ESCOM on how to, I don't know if I will succeed, but I will definitely get some tips from here on how to advise ESCOM on how to control the load shedding, because when it hits, it could be very boring. And I'm sure some of you have experienced the fact that some of us down there, we are unable to join virtual meetings, or we join and then we fall out because power just goes off, even though we have a very, very good schedule that we know. Other African countries do not have those schedules. But thank you so much for this. I will definitely make sure it goes, that I send it to the right people. Are you guys perhaps ready? Or was I? Yeah, you're ready now. So we start with the chair. That's the only person I'm going to introduce this morning. Dr. Demand from the Free State, the Center for Human Rights at the University of the Free State in Bloemfontein in South Africa. She's a coordinator of the advocacy program. Is that right? Yeah, of the advocacy program. You saw her yesterday in the last session. From what I heard from all of you is that yesterday was hectic. It was very hectic, but at the same time very informative in all the sessions. I remember the ones that I attended in person, mostly the other group, and then now and then this group that sat this side online as well. It was extremely rich, and we had a very long meeting after the sessions to discuss the issues of publications and the strategy, how we move forward to publications. All of that will be discussed when we are done with all the panels. We'll just brief you on things that we have discussed and the way forward when it comes to publications. Right. But without much ado, today we are going to have two sessions. The first will be chaired by Dr. Demand, who is right here with us, and then the second will be chaired by Dr. Bebe. And then immediately after that, we are going to move into the GA. I would like to encourage all of you to join. I just had a conversation with the Secretary General of the Ancl a few minutes ago to say that the structure of this AG or this GA will not be the same as we had in Botswana and Lagos and other countries that we've been to, because when we look around, we see more of prospective members than actual members of the ANCL. So we will look at it more from the angle where we try to position the ANCL in a position where it lures or gets most of you to be part of us, and then we continue the conversation. Those who are actual members, most of them are actually online. They will join us at some point for the GA, and then the big announcement will be where next. Where do we go to next with our conference, and then the other symposiums or colloquiums that we are going to have before we get to the conference in 2024. Without much ado, ma'am, over to you. Thank you. You put it off.
Good morning, everyone. I'm happy to see everyone's came back this morning. I know a 3-day conference can be a long time, but as mentioned, we only have 2 panels left, so I think we can keep the energy up for this last two panels, and I know that we've got 3 very interesting presentations coming up. So I think keeping with the trend of the program, we're going to switch the program around a little bit. We're going to start with Prof. Angela Dube. Prof. Dube holds a Doctor of Laws with specialization in International Criminal Law, Universal Jurisdiction from the University of the Western Cape, as well as a Master of Business Leadership from the University of South Africa, LLM and an LLB. He is a professor in the Department of Public, Constitutional and International Law at the University of South Africa. The topic of his presentation today is police discretion in the arrest and detention of children in South Africa as expounded in Raduva versus Minister of Safety and Security and Elaine Africa versus Minister of Police. I think we'll just wait for the PowerPoint to come up for Mr. Dube, if that's correct. We're going to give the speakers 15 minutes each because we're just a little bit less today, and then we'll have 15 minutes for questions and answers after that.
Thank you, Madam Chair. The title is Police Discretion in the Arrest and Detention of Children in South Africa, as expounded in Raduva versus Minister of Safety and Security and Elaine Africa versus Minister of Police. The 2 cases are similar, but they have slight differences. In the Raduva case, the police came to arrest the parent. The child tried to interfere. The police took the child as well, arrested her. And so then the lawsuit ensued from that, from the minor claiming damages for being arrested in the manner that she was arrested. In the Africa case, the police came to arrest the parent. And then the story is a bit fuzzy on how the 2 children, twins, who were 1.5 years old, got to be arrested as well. Not properly arrested as you would arrest an adult, but came to be detained, to be with the mother in the holding cells. So in the Raduva case, as I said, the mother had violated a protection order, and when the police came to look for her in the house, there was an argument between the police and the mother. The child stood between the mother and the police as a human shield there to try and protect the mother from the police. Present in the house was the husband, but when the police saw that this child was making their work difficult, they decided to arrest her as well for obstructing the work of the police. They held her and the mother in the cells for 19 hours and then released them after that. The prosecutor declined to prosecute this case. They said they're not going to go ahead and prosecute. So the question then that came to court was this warrantless arrest unlawful? Because when the police came there, they only had a warrant for arresting the mother only and not the child. They arrested the child because she interfered with their work. So the question was this a lawful or an unlawful arrest? And there were 4 considerations. Section 28 sub 2, in fact, about 3 considerations, yeah. Section 28 sub 2, Standing Order G 341, and Section 40 of the Criminal Procedure Act that the court had to interrogate to try and figure out if this arrest was constitutional. At the High Court, the lawsuit was unsuccessful. They were trying to sue for general damages, for contumalia, and for estimated future medical expenses, because the minor, after being arrested, had to attend psychology, assessments, had to go and be with a therapist for her to to begin to function normally as a normal individual after the trauma of being arrested. I'm on slide number 4. After being arrested, so they appealed unsuccessfully through all the levels of appeal, from the High Court to the Supreme Court, still unsuccessful, and got to the Constitutional Court. At the court had to determine whether the arrest was in the best interest of the child. So in order for the court to try and understand if this arrest could be defended, they had to interrogate the concept of the best interest of the child, which is in section 28, subsection 2 of the Constitution of South Africa. And also, it also features as part of South Africa's obligations under many of the international instruments South Africa is party to, such as the CRC, ICCPR, African Charter, and so forth. So the court also had to look at how a treatment or a consideration of section 28 sub 2 impacts on police powers to arrest under section 40 of the Criminal Procedure and Evidence Criminal Procedure Act. So the best interest of the child basically is a concept that treats the child as a legal subject with full agency, akin to an adult. So the child is not just a thing, it's not just an entity, but it's a legal subject with full rights, such as the same as an adult would have. It acknowledges that the child is vulnerable. It acknowledges that the child holds a weaker position in society, and as such requires protection, which is why the Constitution included that concept as part of the provisions in section 28 sub 2. The reason the court went into standing order G341 was that standing order stipulates that a minor can only be arrested as a measure of last resort. Yes, the minor was interfering in the work of the police, but if this was indeed a violation of the law, was this the best way to actually bring the minor to justice? Were there no other means of bringing this minor to justice? So standing order G341 stipulates that a police officer must look at the situation and ask themselves if arrest and detention is the best way to go about bringing this minor to justice. Is it in the best interest of the child to actually arrest and detain them at that particular moment? So, like I said, the rationale is that the accused can still be brought to court in any other way. They could have informed the child that he was being arrested for that particular interference with the police. But because the father was at home, they could have left the child in the care of the father, and through the father, they could have brought that child to court on the date of the hearing. So the failure by the police to then consider those standing orders in determining whether or not to arrest will render a warrantless arrest unlawful. Section 40, the other question that had to be dealt with was the police were of the view that our power to arrest is guided by section 40, sub 1 of the Criminal Procedure Act. As soon as we tick all the boxes there, we can then go ahead and arrest. The applicants or the appellants were saying, yes, you can go through all those steps in section 40 sub 1B. But when you come to the end, even if you tick all those boxes, you must still look at section 28 and ask yourself if this is in the best interest of the child. You must still consider that standing order that police are bound to consider, and ask yourself if arrest is the best way to go about doing this. Have you considered other means of bringing this child to court without necessarily arresting them? You must, in other words, consider arrest as a last measure of resort. So section 40 sub 1, I'm on slide number 7. Section 40 sub 1 lists those 4 jurisdictional facts that need to be satisfied, that the police officer must go through before deciding whether to arrest or not. The arrester must be a peace officer. The arrester must entertain a suspicion. The suspicion must be that the person has committed a particular offense, and then the suspicion must be on reasonable grounds. In other words, the suspicion must not, the suspicion must not be informed by your own whims and your own caprices as a police officer. My technical team, I am on number 7, and let's say judiciously or not, the arrest must not be based on a whim. I'm going to number 8 now. The arrest must not be based on a whim. It must not be despotic. It must not be capricious. You should not be arresting this minor simply a person in conflict with the law, and you must follow the steps. Whether you think this is a child who needs to be spanked and taken away and arrested is neither here nor there. That would be capricious. That would be basing your suspicion on or your reasons for arresting on a whim. So the applicant argued that to interpret this properly, to figure out if, to interpret section 40 properly, you must consider the following. Detention is a last resort. And section 28 sub 2, the percentage of the child must be regarded as additional requirements to section 40. They were trying to get the court to expand section 40, to develop section 40, to say when a police officer determines whether to arrest or not, over and above the elements listed in section 40, they must also section 28.1 on detention as a last resort, and section 28 sub 2 on the percentage of the child. So they wanted this to form part of the metrics that the police must go between arrest and detention. They must treat the two processes as the same, simply because the person involved is a minor. And the court was not having any of that. The respondent wanted the two to be separated, and the court sort of aligned with the 35. Separates the rights of those who are detained from those who are arrested, because these are two different categories of persons. You may be arrested and not necessarily detained. You may be arrested and released. And you may also be arrested and detained. Certain rights are tasks of persons. So the court was of the view that these two must not necessarily be conflated simply because a child is now right on one question. Whether the police officer of Sekoto, the court found that there was no such obligation. At the end of the section 40 assessment, the police officer still has a discretion. He may decide, I'm going to arrest this one for reasons 1, 2, 3. For example, he might be a flight risk. I will leave this minor in the custody of the father. The father will have the duty to bring this minor to court when called upon to do so. Therefore, this person has violated the law, but this leave this person in the custody of the father. 2 minutes, okay, thanks. So the police, the court was of the view that the police did not necessarily have to arrest this girl. She could have been brought to court. The other consideration that made the court come to that conclusion was that the child, when detained, the law requires that must be detained for the shortest possible time and must be separated from others who are above the age of 18. So you can't arrest a child and put them together with adults. Which brings me to the case of Elaine Africa versus Minister of Police. Elaine gets arrested together with her husband. The story is very fuzzy on where they were arrested. Elaine says they arrested the husband, then they came looking for her. They found her walking along the road they took her to. And they took her home where the police took the twins as well. Twins were 1.5 years old, to the police station. The police say, no, we came home, we found Elaine there, her husband there, we arrested her there. And as we were walking away, Elaine said, I need my children, I need to breastfeed them. She insisted on taking the children with her. Elaine says, no, I never insisted on taking the children with me. The police simply took me with my children to the police station. The police say the kids never entered the holding cells. And we left these children with the guards, no food, no change of nappies, no bed to lie on, just on my lap all night with adult state. They're making two arguments. The stance of the arrest. You asked for the children to come through. So the court looked at that and decided the arrest was unlawful in any case, which makes the minor's detention with the mother automatically unlawful. But the court went on to say even if the mother's arrest was lawful, to have a minor arrested
Decisions provide the seeds, and if there are constituencies that can water that seed, that can take care of that seed, it definitely provides, it's certainly an enabler for social change. Thank you.
Thank you. I want to ask Dr. Ngwinyana a question. I'm in favor of gender equality, obviously, and that women should not be treated different than men. But I just want to know what you would think would have happened in a case. Say there were 6 children, and the parents decided to leave the property to 3 children, 2 men and 1 woman, and the other 3 didn't get any property. The other 2 women and 1 man. So it's not a gender issue. For some reason, the parents decided those children will not inherit. How far do you think should the court be allowed to go to interfere with the property right of the owner? Because I understand this decision, but I just feel it's very dangerous to start interfering, because specifically in this case, what would you say, what should a court decide? Thanks.
This is Dr. Krishnaris from UNAM. My question is directed at Dr. Haroni in relation to the Somalian crisis. I just want to find out, I've read much about the division in Somalia, Puntland, Somalia, the Republic, and Somaliland. And from what I've observed over time, people of Somaliland want independence from the whole of Somalia. The question is, how realistic is that, taking into consideration the fact that the Organization of African Union and the AU are virulently anti-secessionism. You remember the case of Katanga before the African Commission, in which it was affirmed that the right to territorial integrity is paramount to secessionist activities on the continent. So will Somaliland succeed in this regard? Thank you.
I'm going to stop there for now and hand over to our presenters again, and we can just start in the order that we presented as well.
Thank you, Madam Chair. Let me try and remind myself the 2 questions that were posed, 3 questions actually. The first question was, what can be done to avoid detaining children? Is there a facility perhaps to help in such cases? If one looks at the Africa case that I discussed of the twins, it does not seem like the police have a facility dedicated to this. Because from the court record, the police say, we came with the babies, we didn't take them into the holding cells, we left them with the guards outside. Now, guards are not there to look after babies, but they're here to improvise, which means they do not necessarily have a system. What can be done, I think the state needs to actually take this particular problem seriously and create a system. Because we don't want a case where an offender would simply capture a child, a baby, to avoid being arrested. We need a system where you can take the offender, but take care of the interest of the child as well. And I think currently the system does not have that. And then the second question was on ethical considerations amongst the police. What can be done to educate the police? Obviously, this case indicates that there's a serious lack of preparation for the police for them to do their work. If you look at the arguments that they were raising, arguments such as, no, you asked for the children to, you insisted. What could we do? You said you must bring your kid, you want to breastfeed them, and you brought them. This is coming from an officer of the law. Is this nothing wrong with the fact that twins were crying all night with strange adults, non-happy changes inside a holding cell, simply because their mother is a suspect? So there needs to be an overhaul of this, of the syllabus at the police college in how we educate them. Then the last question was on taxpayers' money. There's quite a lot of money that's being lost. In 2021 alone, mid-year, 140 million had been paid through orders of court. The court ordering the police to pay for wrongful arrest and stuff like that. 9 million extra was out of court settlements, that they had to deal with. Usually there's a budget of over 300 million for such things. The police know it's going to happen. They have a budget for it, over 300 million. I think voters cannot hold government accountable. Unfortunately, voters will keep putting them into power. Civil society seem to have power at some point, but if they still can't be able to use the courts to challenge some of these things, that's the only solution we could have in this regard, to push government to find proper solutions to this thing, because voters will not hold government. Give them a T-shirt written ANC, they'll vote for you. Send a bus to take them to a rally, give them free food, they'll vote for you. Whether you lost 300 million on police misconduct last year, they don't care. As long as you can say something that's catchy and exciting at their rally and give them a free T-shirt, they'll vote for you. So I think the solution lies with civil society, because government itself will not address these issues. The voters will not hold government accountable. So the only solution then is civil society and the courts. Thank you.
There are 3 questions that is directed to me. The first question is the involvement of regional and international partners. The involvement of regional and international partners in Somalia. Yeah, they are. They are involved, very much involved. They have contributed millions of dollars. Actually, some of those money that are contributed by international communities and the regional countries have become a prize to be won by the elites. They are fighting on that. They are fighting on how they can capture those resources. But also, the regional international communities have also contributed peacekeeping forces. They used to be AMISOM, now ATMIS, African Transition Mission in Somalia. So they're actively involved in Somalia. The second question that was asked by Professor Adam, I think he stepped out, is if Somali government, the federal government and federal member state could coordinate the activities in fighting Al-Shabaab than fighting among themselves, if there is that possibilities. Yes, of course, there are possibilities. The previous regime, they've had a lot of problems, especially with some of the federal member states. But the current government that came into power a few months ago are approachable. They're reaching out to the federal member state. They're talking to them. And they're coming up with a number of strategies of fighting Al-Shabaab. The key among us that is appointment of Mukhtar Robo to a ministerial position. Mukhtar Robo was a former Al-Shabaab spokesperson. The former Al-Shabaab spokesperson was appointed a full minister. I think this is a first bold move in fighting Al-Shabaab. The last question that I was asked is the issue of independence of Somaliland. Somaliland is the most peaceful part of Somalia. Actually, the most peaceful part of the Horn of Africa. They have established firm rule of law. They're enforcing it. They have had a number of successful elections. And you have seen a peaceful transfer of power from one civilian to another over many years. They have schools, they have running water, there are telecommunications. Honestly, I don't see why they should not be recognized. Somalia, it will take long, it will take ages for them to let Somaliland go. They still want to be, they still want to have power over Somalia. But that is going to be a big problem because Somalia itself, there's a lot of problems. Somaliland says that there are no honest brokers in Somalia that they can talk to about their problem and grievances. Also considering that early 1960s, Somaliland was an independent country for a few days. And then they thought that, their unity is in them coming together as one Somali. That's why they joined forces. And then under the national government, they suffered a lot. I'm sure you're read on that. They have really suffered a lot. And for the years of the conflict, they seceded from the Somalia and they have established, a peaceful part of Somaliland. So I don't think it's possible, but we'll see how it goes. Yeah. Thank you so much.
Thank you, Chair. Thank you, colleagues, for the questions and the comments. I would say that I think your question and hers, they are more or less the same. So I would say that, when it comes to the alternatives because you find that whenever we move to the court, that's which other solution. But we want to leave it to the court to provide us with a mutually acceptable outcome. So I think it starts with us, especially us lawyers who are drafting these wills. Remember, this one was drafted in 1902. It has been an old will, and then the children of Mr. and Mrs. Diager did inherit as they were sons, and then the one of the children who bear daughters, they could not inherit, and then they found out in 2015 that how the will has been. So you see now, so it starts with us lawyers to ensure that whenever we draft these wills, there is an infusion of human rights there, because we are required in terms of transformative constitutionalism to ensure that. As well, I think we should continue with more wills week. Like I think the center, at your center there, you do a similar thing in terms of the Wills Week and all that. I think we should bring more awareness of that. But I'm not saying that we should really this. The question is that should crossed or diminished, or whether the achievement of equality is promoted or undermined by that particular clause in a will. So one has to have that in the back of their mind, because if we fail to adopt more innovative approaches to ensuring substantive equality, it will entrench formal equality in the expense of substantive equality, especially if we are not careful. So I'm saying that we should not dilute freedom of testation, but there should be a balance. The freedom of testation should not be taken as an absolute right. It is not absolute. It think of equal distribution of what? Of wealth, because that's the commitment of what? Of transformative constitutionalism. So we must ensure that socio-economic resources are distributed equally amongst ourselves. So I think there is no way of good way. There's no best solution to it, but we must try and infuse human rights in every decision that we make. We should not say this is private, so it must be dealt with in a private manner as you see fit. But it must be dealt with in a manner that it ensures that human dignity, equality, and freedom are upheld. Thank you so much. I've answered all the solutions. But it starts with us lawyers who draft these wills. Unless the particular person has they've on their own drafted the will, but that we will have to have more awareness weeks, Wills Week that we usually have in South Africa to get the message across on how the drafting should be. Thank you so much.
Thank you. Is there any other questions? One question there. One question there. Okay, I think we'll do those two questions, and then we'll give the presenters time to answer and do concluding remarks, and then we'll move on from there. Thank you.
Good morning. My name is Abigail Witumelo Mushandami. I'm from the University of Namibia. Mine is more so a suggestion, as Dr. Lerato called for suggestions on the development of his paper. And I think that it would be interesting to explore the intersectionality of gender inequality as well as poverty in South Africa, because it doesn't seem as though there are a lack of cases because there are no issues when it comes to testation. It just seems that there's a lack of the financial capacity to explore the legal routes, as well as exploring the way in which the South African Constitution protects the right to culture but also limits it, because, and doing a comparative analysis between Namibia and South Africa, because in our constitution it is provided that you may practice your culture according to Article 19, but there is also a limitation that if it is in contradiction according to Article 66, that if it is in contradiction with the Constitution, then there can be a legal limitation. And I think that's quite important, because although we want to protect culture, we also want to see a progression in society so that it reflects our needs. Yes.
Good morning. My name is Newaka Jisa. I'm from the University of Namibia. Mine is a comment to Prof. Dube on the police arrest. I think what we need to do as Africans, we should start from that 6 to 9 months training of officers. I think we should include a course whereby they sit in class and they are taught as to how to execute some of their duties. Most importantly, if I have to go in the case of Namibia, I would look at Article 12. If a grade 10, somebody just go and read Article 12, I'm very sure they will not understand in details as what it's trying to stipulate. But if there's a legal specialist that explain in details as to what Article 12 means and how to execute that Article 12, I'm very sure they will do their arrest in a different way. And I'm very sure it will improve them. And to Prof. Orato, I totally agree with you. As you said, the responsibility is with lawyers and people within the legal fraternities that help with drafting of wills. I say this because as a lawyer, when you're drafting a will, you should also know that as far as you're trying to uphold somebody's freedom of testation, it's also subjected to limitations which are statutory and common law limitations. I'm sure in South Africa we have statutory limitations, and in Namibia we have few, and common law limitations are there. So this arrest is with lawyers, and they should uphold this within their execution of wills of their clients. Thank you.
Thank you, Madam Chair. My name is Rana Kamatoto from the University of Namibia, and I also have a few comments to add on to what my learned colleague just added. This goes to Dr. Dube and Dr. Ngwenyama. What I picked up from both scenarios is that I feel like in Africa we lack the resources to give police officers mental evaluations and emotional evaluations, because sometimes they might know exactly how to execute the arrest. However, this man is probably not in the capacity to apply his mind correctly and just decides, you know what, I'm going to do what I want and arrest in the manner that I feel fit. And sometimes this is also just a lack of that evaluation. They need to have a grid or a standard where they say, this police officer is mentally capable of carrying out his obligations and his duties in the way that is required of him in the duty that in the position that he holds. So that is also maybe one of the reasons why a lot of police officers commit crimes or execute unlawful arrests. They just decide that maybe perhaps I felt this type of way, I lashed out in the way that I did, and there are no repercussions for that. So in order to prevent this, maybe mental and emotional evaluations could also be incorporated in our African societies. Thank you.
Thank you. I'll hand over to our presenters again, and I think Prof. Dube also has a question for one of our other panel members.
Thanks, colleague, for your suggestions. I think what I take from him is the need to actually strengthen the syllabus and ensure that police are actually taught their recurring courses, refresher courses for this. What I take from you is that there's a need to give that training plus support as well as evaluation of the people that get recruited in the police force. You'd be amazed at the number of police officers who are fired because they had a prior criminal record that was not picked up during the hiring process, and that really leaves you astounded. Like, how do we recruit if we're going to be recruiting criminals? I abused the podium and I asked for an opportunity to pose a question to my brother. I was in Somalia 2007, and you're right, it's a very peaceful country. Even met the president there. But the issue of recognition of Somalia, what is the AU doing about it? I know that Somaliland has been lobbying a lot, globally, has been lobbying a lot for recognition. It's not happening. They've been to the UK, not that that's the route to go because we're trying to decolonize everything, but they've been to the UK, they've met members of parliament in the UK to try and lobby internationally. What are they doing on the African continent to lobby? We've seen America rushing to Taiwan to try and give them some sense of being a state in the past few days, even though in Africa only the state of Swaziland recognizes Taiwan. But we've seen how these big powers can go there and try and clothe a state with statehood and push it towards recognition. What is, do you perhaps know what the stance of the AU is towards Somaliland and what Somaliland is doing to lobby within Africa for its recognition?
Thank you so much. Yeah, it is true. Somaliland is the most peaceful part, and they have tried so hard to reach out to international community for their recognition. They have shown the world that they are capable of being an independent state. Actually, they are more stubborn than South Sudan. I don't know why South Sudan was recognized and not Somaliland. But that's, it's international politics. African unions, they are also more dependent on what's happening in the international arena. They're more readily recognized outside forces than African problems. So it's tough. It's geopolitical things, but it's our sincere hope to see that one day Somaliland is recognized. Yeah.
Thank you so much for the comments and the suggestions. I'll do incorporate them as I continue shaping the paper. I think I'll say that in adding to the suggestions, my last words as well is that, the law, we know that the law both shapes and contracts relationships in the society. But in addition to the role of the law that it plays within societal relationship, it also draws the underlying moral and value choice of the society. So in this sense, the law should not be granted or should not be regarded as a neutral set of principles that has no bearing on power dynamics in society. So the essential point here is that the law is not a neutral or a moral enterprise, but it is based on the interplay between its constructive role of shaping society and the underlying moral or value choices which also shape our equality jurisprudence. So in this particular case, because each and every case is context sensitive, like Gerda mentioned, that it cannot be a blanket application. So in this particular case, we see that the law has distributive consequences because absent the proper application of the equality jurisprudence, the powers, privileges, and liabilities of both individuals and groups in society will go unchecked. So it should not be like that. If we see that the common law, private law is not proper in this context, we should test it against our constitutions and also our traditions or cultures. They should be practiced in line with the constitution to ensure that we establish that society that is based on human dignity, equality, and freedom. The rights should not be just lofty ideas to some, especially those who are in the margin, the vulnerable, especially women as well. So they should not have a distant dream of human dignity, equality, or freedom just because you have the bargaining power in terms of drafting that will or in terms of having the economic power. So the scale should be balanced. Thank you so much.
Thank you very much, and I think we'll end the session then there for now. Yes, if you want to catch up with our panel members again, you know, we've got the coffee break coming up, and we've got the dinner tonight, we've got lunch, so please feel free to, I'll put them on the spot and say that you can just go up to them and speak to them again. I'm not sure when we would be coming back. Is it 11:15?